She called me. Hillary called me. I don't know if you'd talked to her.
I texted with her.
And she said that when I get out of here, I got to call Dustin, finish setting everything up, then call her so she can call you to confirm everything.
Okay, this is on case number 241384, and so you've already talked to Heather.
Yeah, she called me.
And she texted me. And she said she wants you to call the office again,
Yeah.
make an appointment, and then.
Yep. Then I got to confirm with her so she can confirm with you.
They're going to start you on the MAT, medically assisted treatment, and you're going to go to Prestera for therapy, but
Yeah.
they're going to set that up for you. So.
Yeah, I got to call Dustin as soon as I leave here, and then call her, and she come.
Okay. So February 24th, then we'll just keep that.
Oh, I
day.
wrote it down.
Yeah, it's in there at noon. So
Noon.
you need to be here. Go ahead and do your treatment as it's been set up with RRG and Prestera. Be back here, make the phone calls they've set up for you to do. Be back here in 2 weeks from today. Your next hearing at noon.
Okay. All right.
Call Mr. Lockman. I think he wanted you to call him too, let him know what's going on.
Oh, yeah, okay. All right, thank you.
You're welcome.
State of Ohio versus William Earls, case number CRB 24788.
This is on the docket for trial today. Mr. Earls is represented by Mr. Morford. It's afternoon. Mr. Earls is not here. Do you have any idea where he is?
I do not, Your Honor.
And state wants a warrant.
Yes, Your Honor.
Bench warrant will issue for failure to appear.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Paul Mann, case number CRB 2574.
This is for arraignment. And sir, you're Paul Mann.
Yes, sir.
And bailiff's going to bring you a copy of the charge.
Now, what's this now?
That's a copy of your charges.
Okay.
Let me explain to you what your rights are before we start. You have a right to remain silent. You don't have to say anything. You have a right to have an attorney, to have one appointed if you can't afford one.
I can't afford one.
You have a right to bail and to make the state prove this charge beyond a reasonable doubt. Do you understand those things?
Yes, sir.
Okay, you've been charged with domestic violence, and that's what the paper was you were just handed. It alleges that on February the 8th, in Fayette Township, you not only caused or tried to cause physical harm to Carolyn Slack, and that Carolyn Slack is a member of your family or household. So that carries a possible penalty of 6 months in jail, $1,000 fine. That's the most the court can impose if you're found guilty. You understand the charge?
Yeah.
And you understand your rights?
Yeah.
How do you plead to this charge?
Not guilty.
Do you want a lawyer appointed to
Appointed lawyer.
Are you working?
No, I'm on SSI.
The SSI is your
Yeah.
only income?
Yeah.
Okay, is Mr. Steyer still here?
I am.
I'll appoint Mr. Steyer to represent you. Not guilty plea is entered. And I think I saw Carolyn Slacks on the deal list.
Yes.
We're gonna have her. So.
Is this a cross-filing
Looks like
situation?
it must be a cross-file situation. Let's talk about the living arrangements. Have they been living together? What we're gonna do on protection order? Does he want a protection order? That sort of thing.
I think if she wishes a protection order, we obviously would wish to have reciprocals. If she doesn't want a protection order, are you okay with that one?
Well, I don't want to back to nobody else.
Do you want it? Okay. So we may want the protection order, in which case I'd assume the state's gonna.
Well, then we gotta figure out who's gonna live where.
Well, I live in my camper. Because that's what we lived in, camping.
You live in a camper?
Yeah. She stayed in the back bedroom, I stayed in the front room.
In a camper?
Yeah, camping, yeah.
Okay, but you don't want her back there?
No.
Does she have another place to go?
I don't know.
Well, you know better than I do. Does she have family or anything locally?
she told me she didn't. It's kind of, her kids don't even any living on her. That's what she told me.
Okay,
I can't live in the same house she does. I'm gone all the time. At 8 o'clock, my buddy called me, I go down and have coffee with him till about 2 o'clock, and then I
okay,
come
you're not
home.
out working then.
No,
Well, we better come back pretty quick under these circumstances, as soon as.
I'm here Friday.
Okay, let's just set it for Friday, because this living situation seems
what, this Friday?
difficult.
This Friday.
This Friday,
Okay,
Valentine's Day.
okay.
That'll be the next hearing, February 14th. It's gonna be a busy day.
All right, I'm gonna ask you to
Just don't plan on spending any time with your family.
wait for me out there in a minute.
Okay.
I gotta get your file. Thank you.
So there's gonna be a protection order?
There's a
We're asking.
protection order, you'll need to sign that, and he's got a bond out.
He's not leaving up there.
Oh, okay, I'm sorry.
Just wait for me in the lobby.
Thanks about it.
And don't, oh, do you have it ready? I didn't have it ready.
Next hearing is Friday at 10 o'clock. With bond.
Here.
Your Honor, we're ready to entertain it.
What's his last name?
See who?
Yep, right there.
Barber. That's what Barber.
But they'll contact you.
And here. Yep. And when I get done with you, you don't leave until she gives you a copy of this.
Okay. I'll make sure.
Yeah,
Thank you.
thanks.
State of Ohio versus Ethan R. Anderson at Orange County Jail. Case number CRA
Okay, I'll be out there.
24706. Antonio Caldwell.
Oh, he said, I didn't know if I was excused to leave.
This is Tyler Smith's case, I think he's still here.
Yeah.
Right, Ethan Anderson is in jail, appearing on teleconference. Mr. Smith is his attorney. It's alleged that he failed to appear November 15th, I think it was. Is that correct? He had failed to appear back in November for preliminary hearing.
Yeah, I don't have a file for him today, so I didn't know if he had been picked up and was going to be arraigned.
He left, I've got a letter from Bethesda dated November 11th, 2024, saying he left treatment there ASA. And he was released on November the 8th on an OR bond to go to Bethesda. So he was there 3 days, looks like. So how's the state want to proceed?
Well, Mr. Anderson got released to Bethesda after a day or two, it looks like. And the reason was because, well, let's see, we were here on November the 8th, and we talked about him going to Bethesda. We wanted the GPS monitoring. It wasn't available. And even after a week, it still wasn't available. So we kind of shrugged our shoulders and said, we don't want him in jail.
And the instincts about the monitor were right,
Yes.
apparently.
So we wouldn't want him released at this point unless there was electronic monitoring. Also, originally, the resisting arrest was charged as a felony. We amended that to an M1. So we have an M1 resisting and an M4 disorderly pending.
So there are no longer any felonies coming, they're all misdemeanors.
Yes. So, I mean, I assume that when we discussed him going to Bethesda previously, it was with good reason.
Was it for mental health Mr.
May I say something?
Well, Mr. Anderson, it's Tyler Smith, it's your attorney. Were you released to Bethesda for mental health?
It was for drug. I had a drug problem.
Okay, I didn't know if mental health was involved too, so, all right.
Attorney, may I say something? It's not going to hurt my case any. I'm very keen to LexisNexis models. I just wanted to say, sir, that me being at Bethesda pushed me towards the door like very bad because I know a lot of the co-workers there, and I'm not far from my house because I've got a house in South Point and I also have one out 243. And I could literally throw a rock and hit my prior using spots from Bethesda. So I just wanted to make sure that was known.
Are you willing to go to another facility if you were to get out?
Another treatment facility, yes, but I feel like if I'm at Bethesda, all I'm going to think about is smoking crack. With lack of better words, I know that's really stupid of me to say, but that's all I'm going to think about.
I mean, if the state's willing to allow them to go somewhere else on GPS.
Well, I mean, I think he needs to go to treatment.
That's on
And we do,
Justin.
now we also, of course, are still taking the charges seriously, so I don't know whether this is a situation whether you would feel that you'd be in a position if he pled guilty today to advise him one way or the other. And then put him on probation and.
No, I'd rather him get out, get in the treatment, and come back, and then make sure he's in treatment.
Mr. Turbin, this may be a gentleman that would be appropriate for your facility because it sounds like he has a lot of triggers here locally. He admits having a problem with crack. His name's Ethan Anderson, and he's got 2 misdemeanors.
What county is he from?
Lawrence, I assume you're from Lawrence County originally, right? Because that's where he said his problems originated.
He was at Bethesda and then left after about 3 days.
Stayed 3 days.
Yeah, I do want to talk to him.
Okay, I'm going to have someone from the counseling center call and talk to you and do an assessment. And now one thing you need to understand is if we put an ankle monitor on you and you cut it off, because that's the only way you can get away,
Yeah.
you're going to go to prison.
Yes, sir.
For cutting the ankle monitor. The drugs won't have anything to do with it. It'll be for cutting the ankle monitor on. Everybody that's done it has gone to prison.
Yes, sir.
So, okay. Mr. Turbin's going to call, talk to you, and then I'll have you back. We'll finalize things for treatment.
State of Ohio versus Antonio Caldwell, case number CRE 2572, and Seth Coleman is on deck.
So to Jones, tell her to go and sign this. It's fine.
Mr. Smith and Mr. Turbin, good thing that guy still has, he has a felony file coming too from our municipal.
What's it for?
I don't know.
Oh, okay.
I'll explain that.
Okay, thank you.
Sir, are you Antonio Caldwell?
Yes, sir.
Mr. Caldwell, I'm Judge Kapler. This is your arraignment hearing. The allegation is that you have a warrant out of Kentucky, or is it? I've got two. One says Kentucky, one says West Virginia.
No, I ain't never.
Well, the waiver says. I'm going to amend it to say Kentucky.
I ain't never got in trouble there.
In West Virginia?
Yeah, I ain't never got in trouble.
Excuse me. You've got, it's alleged there's a warrant for you in Boyd County Circuit Court, and you have a right to an extradition.
Yeah.
It's on a non-support. So you can have an extradition hearing in this court and even have a lawyer appointed. The hearing would be about whether there's good reason to send you to Kentucky. You can waive extradition. That means you're agreeing that you need to go to Kentucky and clear this up. If you do that, I'll give you a bond. They're asking for no bond. Yeah, I'll probably set a bond if you can post it. I'll let you go there and turn yourself in. If you can't post it, I'll order Boyd County to come get you.
Can you let me sign myself that I go up there?
No, I can, but I'm not gonna do that. I'll set a bond. If you can post a bond, then I'll let you go turn yourself in. If you can't, then I'll order them to come get you.
All right, well, they can come get me, but I ain't gonna do it.
Okay, but you wanna waive the extradition hearing then? You don't wanna have a hearing about whether you are the Antonio Caldwell of Kentucky is seeking and I should make you go there. You're agreeing that you're the Antonio Caldwell they're seeking and that you should go to Kentucky.
Oh, yeah, I don't have no choice, so I just.
Well, you can sit in jail and we can have a hearing about it, but it's just gonna delay things. It's not gonna resolve your case.
No.
And you can't get out.
Tell them come get it.
Okay. So I'm gonna send a waiver down for you to sign. I'll put an X, big X where you need to sign it. I'm gonna set bond at $5,000, which you can't post.
Yeah.
So I'm gonna give them a week to come pick you up.
Okay, buddy.
So that they should be here before then.
All right, thank you, buddy.
Actually, it'll be the 18th since the 17th is a holiday. So they have until the 18th at 8 a.m. to pick him up. So if someone from the jail's listening in, let Boyd County know he's available to be picked up now.
All right, thank you.
You're welcome.
State of Ohio versus Seth Coleman at the Lawrence County Jail, case number CRB 23-748.
So on Caldwell, he's on the docket for 10 a.m. on the 18th. In case he is still sitting in the jail. Okay.
Seth Coleman, case number CRB 23-748, and Wilky Dial is on deck.
Okay, Seth Coleman is 23-745. Sir, are you Seth Coleman?
Yes, I'm Seth Coleman.
Mr. Coleman, I'm Judge Capper. I'm at Chesapeake. I'm good. I'm at the Lawrence County Municipal Court, and your image is at the court. You're appearing in the courtroom on a television monitor, and it's all being recorded. You have a right to remain silent. You don't have to say anything. If you choose to make statements, they can be used against you. You have a right to have an attorney, to have one appointed if you can't afford one. You have a right to have bail to make the state prove the charge against you beyond a reasonable doubt. And this is an old charge. It's from December of 2023, December 4th, 2023 to be exact. It's aggravated menacing. States alleging that on that day in Fayette Township, you caused Joanna Conwell to believe you would cause physical harm to either her person or property. That's a first-degree misdemeanor, maximum penalty 6 months in jail, $1,000 fine. Do you understand the charge?
Yes, sir, I understand. Is there any way that I can say something?
Yeah, you just understand anything you say is being recorded, so if you admit something, it could be used against you.
Yeah, like I was, when I was supposed to go to court, I was already in the ODRC in prison.
Okay.
And she is my aunt by marriage. I've been known her since like 1997, 96. And we would see each other pictures, new pictures. And she was sending money to my cash app for me to do it. So when I told her no, I don't want to do it no more, she told my fiance, and that's what all this started about.
Okay. Well, I'm going to take that as a not guilty plea. Do you want a lawyer appointed to represent you?
No, sir.
Well, you probably need one, don't you think?
I mean,
Obviously, you don't have any money. Do you have any money?
Do I have any money?
Yeah. You're not working, are you?
No, I was in college and I was getting ready to start doing my welding degree.
Well, I'm not meaning it as a dig or anything, but if you don't have any income, you're eligible for a court-appointed lawyer.
Okay, sir.
So let's give you a lawyer. We got any still around?
Well, I would hit the guilty plea and try to either bond out or just.
Well, we're gonna talk about that next. I'm gonna appoint you a lawyer. His name is Steyer, Mr. Steyer. He's here in the courtroom. He's gonna be your lawyer. So if you do get out of jail, where will you be? Will you be at Adams Street in Iron?
Yes, sir. Me and my mother live there.
918 Adams Street.
Yes, sir.
What's your mother's name?
Seth Coleman.
Jovetta Coleman, okay. And do you have a phone number where you can be reached?
Yes, 740-532-9212.
9212?
Yes, sir.
Is that her number?
That's the house number, sir.
Okay. State have any objection to no R bonds?
We just want to make sure that until we get to the bottom of everything, that he doesn't have to be around the alleged victim.
Oh, I ain't about to be around nobody. I got 4 kids. I ain't got that deal. I literally just came home from Richmond the 7th, and I want to see my kids. I don't.
All right, we're gonna work on that then.
Where does that lady live?
Joanna Caldwell, where does she live? You don't know?
She live in Ironton? Okay.
She in relation to Dane Caldwell?
Yes. I
You
would say
know
so.
that, okay.
Yeah, and I know his family too.
Okay.
So,
So you can stay away from, Dane Caldwell played at WU, didn't
Yes.
he? You can stay away from Joanna Caldwell, right?
Yes, sir. Yes, sir.
Okay, stay away from her until at least you come back to court.
and then, when will we be looking at wanting to come back, Your Honor?
Well, the 24th has probably been a pretty good date, so.
I'm here, so we can put that on there.
Okay, 2 weeks. from
So
today.
you understand that you're gonna have to be back here at court in person in 2 weeks.
Okay, I can do this. That's no problem.
That's 24th at 10 o'clock, and you know where the court is, because you're on video today.
What, sir?
Do you know where the court is?
Yes, sir. Right off the street. Yes, sir.
No, that's not the court. Okay, that's why I want to clarify. You're gonna come to court in Chesapeake across the street from the flea market.
Okay, I know that.
Okay.
Right before you hit this bridge, you go to West Virginia?
No, across the street from the flea market.
That's the mayor's court.
Oh, flea market. Okay.
Across from the flea market.
All right, yes, sir.
It's about a mile back from the bridge, the downtown bridge.
Oh, okay, yes, sir. I know exactly where you're at. Okay.
On old 52 County Road 1.
All right, yes, sir.
So it's Lawrence County Municipal Court. If you can't Google it, and the address will come up. It's County Road 1.
All right, yes, sir.
And you gotta be here in 2 weeks.
The judge wrote your phone number down. That's a house phone, not a cell phone?
Yeah, the house phone.
Okay, I'll call and try to leave a message so that you can get on and do when you get out.
All right, yes, sir. I appreciate it.
Thank
So
you.
you're getting out on a signature bond. So you're just gonna sign a piece of paper that says, I promise to be in court, or.
I'll find right out where it's at.
Well,
They gotta send it to you.
they'll give it to you here in just a few minutes. $1,000 signature bond. Be here in 2 weeks at 10 o'clock. That'll be a Friday morning.
All right, sir.
Okay, that's all.
You get a best day.
That's it.
Thank you.
State of Ohio versus Wilky Dial, case numbers 2569, CRA 2569, CRA 2568, CRB 2575, CRB 2570, and an older case, TRD 154643, A and B.
Sir, are you Wilky Dial? Mr. Dial, I'm Judge Capper at the Lawrence County Municipal Court, which is in Chesapeake, Ohio. You are appearing in court today on a monitor, so we're doing this by teleconference. But everything you say is being recorded, so you don't have to say anything. You have a right to remain silent, but just be aware that it's all going down on the record. If you'd say something about your case that helps the state, they can use it against you. You understand that? Okay, you're exercising your right to remain silent. You have a right to bail and to make the state prove any charge against you beyond a reasonable doubt. You understand those things?
Yes, sir.
Okay, you've got quite a few things here, so I'm going to go over them. And one of which is charges in West Virginia. No, it's Kentucky. I thought it was West Virginia, it's Kentucky. Okay, case number CRA 2568. That is a robbery charge, and it alleges that on February the 9th in Fayette Township, you were attempting to commit a theft offense, and I think maybe there's something left out, but what it says is, February 9th, in attempting or committing a theft offense or in fleeing immediately after he attempts or offense. It doesn't say anything about, I assume there's a weapon or something? It doesn't say anything about a weapon.
There's no weapon involved, but the, let's see. Hold on, I need that.
Maybe it was some sort of fight or something, but there's nothing in the allegation about that.
Yeah, I think what it amounts to is stealing something by using force against a person.
Okay. I'm going to add that there was force used. Force was used, is what I'm going to add. So it was alleged that you used force in the attempt to steal something and committing a theft, so that makes it a more serious charge. It's a felony of the 3rd degree. Maximum penalty for that is 5 years in jail, $10,000 fine. That's case number 2568. Okay, 2569 is the allegation that there is a warrant for you in Kentucky from Boyd County Circuit Court on a failure to appear, and they have a warrant for you and want you extradited to Kentucky. You have a right to have an attorney represent you on that matter and have an extradition hearing. 2570. Alleges that on February the 9th in Fayette Township, without the right to do so, you entered premises and land of another without the right to do that. And I think that was, I believe it was Walmart, was it not?
Yes.
So that's a 4th degree misdemeanor, maximum penalty 30 days in jail, $250 fine. Then there's 2575. That is a theft offense. It's alleged that February 9th this year, Fayette Township, you tried to deprive Walmart of property without their consent. 1st degree misdemeanor theft, maximum penalty 6 months in jail, $1,000 fine. And then there's, finally, the last case is an old charge from 2015. It's alleged that you were convicted of driving under suspension in this court and had a review hearing on that conviction on July 1st, 2016. Did not appear for that hearing and got a warrant for not appearing for the review. So those are all the charges against you. Do you understand the charges?
Yes.
Do you have the money to hire a lawyer?
Huh?
Do you have money with which to hire a lawyer?
No.
Do you have a job?
No.
Okay, is Tyler Smith still here? Should be. All right, I'm appointing you, Tyler Smith, to represent you. The most serious charge he's got here in Ohio is a robbery. There's also a theft from Walmart, and he's got an extradition matter to Kentucky.
Okay.
So they've asked for no bond. Now, the salary's supposed to, I've got salaries written down on here. Did you try to post a bond, or? Did you try to post a bond with Mr. Sowers? No? Okay. Why that's on there, I'll mark that out. What's the state's position on bond for Mr. Dial?
State would request a $15,000 cash or surety.
Okay, I'm gonna set bond at $15,000 cash or surety. Do you understand what that means, Mr. Dial? You can use a bail bondsman. If you've got $15,000 in cash, you post it with the court. As long as you come to your hearings, you get it all back at the conclusion of your case. If you cannot post $15,000, you can use a bail bondsman. You have to pay them their fee, which you lose, which is usually 10%. So you're talking about $1,500. Is that a bond you think you could post?
No.
Okay, so then we need to come back pretty quick.
I'm here Friday, Your Honor, or next Monday.
Bring
or
your
next-
lunch. And then.
I'm also here Tuesday, so. I don't
Okay,
know-
let's do Tuesday.
Okay, I don't know what the time, I don't know when he was picked up, so I assume that's.
Yesterday, I think.
Okay, then Tuesday will be fine.
Yeah. So, next hearing is going to be February the 18th for preliminary hearings and pre-trials on everything. So, Mr. Smith will be your lawyer, and he's going to talk to you at some point before next Tuesday. I don't guess there's any reason to get his phone number since it's not getting
He's
out.
going to be in jail. I can contact the county jail. I would advise if you somehow do make bond, make sure you're here next Tuesday.
At the court in Chesapeake.
Otherwise, you're going to get new charges.
Any questions, Mr. Dyer? Okay, that's all.
Seems a little depressed.
State of Ohio versus David Jackson at the Lawrence County Jail, case number CRA 2547, and Carolyn Slack is on deck.
Sir, are you David Jackson?
Yes, sir.
Mr. Jackson, I'm Judge Capper at the Lawrence County Municipal Court in Chesapeake. This is your arraignment hearing. You have a right to remain silent. You don't have to say anything. If you choose to make any statements, they're on the record. They can be used against you. You have a right to have an attorney and have one appointed if you can't afford one, and to make the state prove the charge against you beyond a reasonable doubt. You understand those things?
I do. Can I say something, sir?
Well, just remember what you're saying is on the record and can be used against you.
It's more like just a question.
Okay, what's your question?
Is there any way I could possibly go out today?
Well, we'll get to that in a minute. This is a fairly serious charge, and I'll ask the prosecutor in conclusion what their recommendation is for bond. It's a felony 3. Having a weapon while under disability is the charge against you. It alleges that on December 30th of 2024, in Union Township, you had not been relieved from a disability to have a firearm and had either been convicted or were under indictment for some sort of drug issue. And therefore, that makes having a weapon a felony to the 3rd degree. The maximum penalty is 5 years in jail and a $10,000 fine. Do you understand the charge?
I do.
Do you have the money to hire a lawyer?
I do not.
Do you have a job?
Yes.
What do you do?
Construction work, SNS construction.
S&S construction?
Yes, sir.
Are you an employee?
Yes, I'm whatever.
Are you paid by the hour?
Take out the day.
How much per day?
When I,
Okay, you're eligible for court appointed counsel then. Mr. Stuyvesant?
but my appointment,
Steyer is going to represent you. He's here in the courtroom.
Sorry.
Steyer.
He's actually my attorney for my other case as well.
Who is this?
David Jackson.
David Jackson.
Okay.
So now I'm going to ask the prosecutor what his recommendation is on bond. What's the state's recommendation on bond?
We'd ask for a $5,000 cash assurance bond, Your Honor.
Does he have a holder out of another court?
I'm not aware of one, but
Do you have a case in common, please, do you know?
not that I know of.
Where was your other case that Mr. Steyer represented you on?
I represented him on a case that closed on, just a second here, I think it was January 2nd.
Of this year?
Yeah, I represented him on a case that closed on January 2nd of this year in Ironton Municipal Court.
Okay.
So, unless there's a probation violation alleged there, that case is closed, so I don't think it would
Okay.
have anything to do with this.
I'm going to set your bond, Mr. Jackson, at $5,000 cash for surety. Do you think you can post that bond?
Would that be $500?
If you went through a bondsman, it would be around $500, and of course, you understand that's a fee that you don't get back.
Correct. I could possibly do that today. I'm hoping I can.
No, I just got a message, he does not have any holders.
Okay. Will contact bail bondsman for you if you wish to have him get in touch with you about posting the bond.
Would you like me to do that?
Yes.
Okay.
When do you want to come back? Are you here the 18th?
The 18th,
I'm sorry?
I can be.
Oh, okay.
We're going to set this for the 18th of February, so that's a Tuesday. Usually court hears on Mondays and Fridays, but the 17th is a holiday, so we'll have court on Tuesday the 18th. That's a week from tomorrow. You got to be in court in Chesapeake then at 10 o'clock.
Okay,
You know where the court is in Chesapeake.
I do.
Okay. Any questions, Mr. Jackson?
No, sir.
February the 18th is your next hearing, 10 a.m. And Mr. Steyer probably would like to have a number where he can reach you.
My cell phone number,
That'd be perfect. Tell me when you're ready.
864. That's the area code.
Okay.
671 8688.
I'm gonna text you. When you get it, text me back and just say, this is David Jackson, if you will.
Okay. I can do that.
All right, February the 18th is the next hearing for preliminary hearing, 10 o'clock.
Thank you.
Thank you, sir.
You're welcome.
State of Ohio versus Carolyn Slack at the Lawrence County Jail, case number CRD 2573, and Ethan Anderson is on deck.
I can't represent her
Okay.
because of cross filing. So.
Well, he apparently they found him with a gun when he already had these charges pending.
Okay, ma'am, are you Carolyn Slack? Can you hear me? Can you sit back a little bit, because I'm just getting the top of your head. There we go, now I can see you. And your audio is turned off, you're in the talk coming through. They'll fix it, it's probably on the headset.
I could be wrong.
There we go, now I can hear you. Can you hear me okay?
I'm sorry,
Can you hear me?
yes, sir. Yes.
I'm Judge Capper, I'm at the Lawrence County Municipal Court, which is in Chesapeake, Ohio, and you're appearing in the courtroom today on a monitor, so everything you say is being recorded. You don't have to say anything, you have a right to remain silent, but you need to understand if you admit something about your case, it's on the record, it could be used against you later. You understand that?
Yes, sir.
You have a right to have an attorney, to have one appointed if you can't afford one. You have a right to bail and to make the state of Ohio prove the charge against you beyond a reasonable doubt. You understand those things?
Yes, sir.
The charge against you is domestic violence. It alleges that on February the 8th, you knowingly caused or tried to cause physical harm to Paul Mann, and that he's either a member of your family or household. So that's what makes it domestic violence. It's a maximum penalty of 6 months in jail, $1,000 fine. That's the most that can happen. Do you understand that charge and the possible penalty?
Yes, sir, I do.
How do you want to plead to it?
He needs my word.
Do you want a lawyer appointed to represent you?
Yes. I saw Mr. Stiles earlier, and he was my court-appointed attorney before.
And I was just looking into that because I didn't recognize her name until I saw her face and realized who she was. My calendar that is on my phone only goes back 2 years and it's not picking up where I represented you. Where did I represent, what court was it in?
Less than a month ago in Chesapeake.
Here in Chesapeake?
Yes.
What
That's
would
why Judge Capper, you just, just didn't recognize me. Rayburn, Slack, same thing.
That's why I got
So what do we do? You haven't talked to Mr. Mann yet, correct?
I was going to take down his biography.
So I'm going to switch it. I'm going to appoint you to represent her since you represented her in the past.
Yes.
And I'll appoint somebody different for him. So Mr. Steyer will be your attorney, Ms. Slack.
Thank you.
And when did I set that for Friday, or when did I set it, or?
You set it for the 18th.
The 18th, okay. All right,
No, you said, I'm sorry, it was Friday, I was thinking the last case. Misspoke.
okay, then we need to set this one for Friday also.
Okay.
Because I wasn't sure if she was gonna get out of jail. I'm assuming perhaps the state's okay with an OR bond here.
State is okay with an OR bond. I hope that Ms. Slack has someplace to go.
Well, I'm assuming.
Yes, sir, I do. I'm gonna go to Mission, just because I'm not gonna take a chance on violating this order. I don't want to miss court, so no.
You're going to Huntington City Mission?
No, right on the street here next door. I didn't know what time, what day it would be. I don't know if I can get a ride this late, but if not, I'll stay down there tonight and go.
Well, they don't let you in until
8 o'clock, I think, is what they told me, yeah, 8.
7. I mean, that's not very good. Then they kick you out at 8 o'clock in the morning, I think.
That's okay. No, I'm pretty sure once I can get to my actual cell phone, I can call and get a ride. That was it.
Okay.
Yeah.
But the main thing is, I want to know that you got a safe place to stay and not around him, because I understand that he's living in a camper and you're not going to go back there, right?
No, sir.
Okay.
No.
Okay, I'm ordering you to stay away from Paul Mann.
Okay, yes, sir.
And he's ordered to stay away from you, by the way, so.
I hope so.
Okay.
Thank you.
And then be here in court on Friday, February the 14th. And you know where the court, obviously you've been here before, so you know
Yes,
where it
sir. At 9 or 10 o'clock.
is. 10 o'clock. Mr. Steyer's gonna be your lawyer.
All
So
right, thank
let's, anybody else still here? Oh, Tyler Smith, yeah.
You want me to take Mr. Mann, is that?
I'll appoint you to represent Mr. Mann. Mr. Steyer can give you his contact.
He did, I've already got it.
Okay.
We figured that's what would happen.
Is 304-962-4430 still a good number for you?
Yes, sir.
Okay,
You guys don't even need me to be here, I can just like take off and work all this out myself.
Well, I think there's only 2 left here, Your Honor. So.
I'm thinking of future stuff.
Oh, okay.
Okay, so February 14th is the next hearing,
Yes, sir.
and she can sign a $1,000 signature bond.
Thank you, Judge. I appreciate it.
State of Ohio recall Nathan Anderson at the Lawrence County Jail, case number CRA 24706.
And Mr. Anderson was going to be evaluated for the counseling center.
I believe he's been accepted. He has been, Your Honor.
Okay. With an ankle monitor? You need that?
That's.
Yes, that'd be our
Okay.
request.
Your Honor, Ireland has not responded
Okay.
to know, so we don't know if they're on board yet or not.
So you'll have to get released too from Ironton Municipal you have a case there, they've got a holder on you, so. I'll let you go to the counseling center with the GPS monitor. You gotta get Judge Waldo to agree with that too, otherwise you're gonna sit in jail.
Yes, sir.
But let's put him back then. When?
We can come back. in a couple of weeks, we can, whatever the.
Let's do the 18th,
18th, okay, I'm here.
All right.
just to make sure things are going the way they should. So,
Thank you, bud.
all right, good luck, do what you
Thank
need to
you,
do,
Doc.
and we'll contact adult probation
Thank you.
about getting the ankle monitor replaced. And you know,
Thanks,
this
Doc.
is serious business, if you cut the ankle monitor off, I'm not kidding, you're gonna go to prison, so don't do it.
Yes, sir.
Is he gonna be released today?
We're finished at the Orange County Fair.
He's gotta get Walter taken care of.
That finishes up at the jail.
Okay. So
State of Ohio versus Tanisha Cantrell, case number CRV 2531 A and B, and Crystal Cantrell, case number CRV 2529, CRV 2530.
Okay.
So what we decided.
I think we have,
Decided on the
Why?
17th.
Wise Path is the name of the place that's able to take them with their circumstances, with the methadone and the Medicaid. And I believe we're going to Morgantown?
Morgantown, West Virginia.
So,
How are we gonna get them there?
I believe they're,
We're gonna be driving ourselves up there.
are you guys both going to Morgantown?
Yeah.
and so, but they
Do they
don't,
have a license?
Not us driving personally. We will have somebody, because we can't leave a car there anyways,
Okay.
they said.
so they'll have transportation up there and then they won't be until the 17th, is that correct? When they
17th,
have a
Monday.
bed? And then hopefully, maybe we reset it after that, make sure they're there.
The
They start-
18th? You're gonna be here, you're both here the 18th?
I'm here the 18th. I'm gonna, if they're going all the way to Morgantown, and this obviously isn't a company we've dealt with in the past, I would ask that they be allowed to appear by video if that's workable, and if not, just get a written report and then make better arrangements for the next time.
Worst case, they could just call him, but I would prefer video.
Right, right.
I've already provided Ms. Cantrell.
Yeah, he did.
With the Zoom information, so they can,
And you can share that.
Yeah, I'll share it with her.
and have them appear via Zoom on Tuesday, the 18th.
Okay, so good luck, and we'll see you on the 18th, we'll set it for 10
Yeah,
o'clock.
let's go up there.
We may not get to you at 10 o'clock.
You wanna write that down, one of you, just so you have it?
Yeah,
need
well, I was
time
going
waivers.
to, but I figured
You're gonna have to
myself
make
in.
sure that that the people that
That I go in.
agency understand that they need to get you onto the call.
Oh, okay.
Yeah, so that's why you have that printout to take to them, okay?
Yes, I'm gonna turn that in as
We
well.
need time waivers.
We'll waive time.
Yeah, but we've
And also, even though they're gonna be going away, some distance away to go to treatment, which we're happy that they're gonna do that, we have these theft charges pending that have to be dealt with.
I'd be happy to, we indicated earlier we would plead guilty to the theft charge in exchange for dismissal of the felony for,
Well, I would prefer, I mean, I'm okay with her pleading guilty, I don't wanna dismiss the felony because that's a whole, that would get her back from West Virginia if she's got a felony.
And we will dismiss the charges later on if they're.
well, my issue
Treatment.
that I end up with on this, which I'm not letting everything pen, but if I plead her guilty to the misdemeanor and then this felony ends up going to the grand jury at some point, ends up getting indicted, then I have severely prejudiced her defense in the felony case. So I mean, again, I'm okay with leaving it all pending, but I don't think it's a good idea for me to have a client plead guilty to a misdemeanor that is the underlying arrest and everything on the felony.
Mr. Hill?
I don't want to take the charges to the grand jury.
I recognize that you don't want to, but that doesn't always stop it from happening.
Right, and I wouldn't do it just because I'm mean either. What I want them to do is to, does your client have a felony drug charge or is it the misdemeanor drug charge?
My client has the felony drug charge.
Mine has the misdemeanor, which she has a prescription for.
Well, I'll tell you what.
Her situation's different, I recognize that.
We'll amend the F5 to an N1.
Well, that didn't cure the
Oh,
problem.
I didn't cure
Get her
that.
back.
Yeah, I got that. Well,
I mean, again, we just leave it pending. I don't object to that,
Okay,
I don't feel comfortable pleading her today with a felony still pending.
well, I guess we could say this, the state is not gonna keep it here unless there's at some point a plea to the misdemeanor theft. It will go to the grand jury if
Right.
she wants to contest the theft. I think that's pretty clear.
Right, that ends up where we are, then we'll,
Yeah.
figure
Okay,
out
so
from
we'll leave
there.
it pending, so we got at least over the one defendant. And what's the relationship here between?
Mother-daughter.
Okay. So, let's put it on the docket for the 18th, it'll just remain pending. But with the understanding at some point, the theft charges will be pled to, or hers will go to grand jury, hers won't.
Actually,
But with the hope that they'll get in treatment and recovery, and then any drug matters can be dismissed.
No. Gotcha.
Thank you, Catherine.
Good work.
Thank you very much.
Okay, court's adjourned.
Might be able. I'm not able to say completed the contest. That's fine. Well, I know.
Yeah, this is,